Tak jo, vážené dámy, vážené pánové, já vás srdečně přivítám na dnešní odborný seminář k tématům regularizace. Já bych vás poprosila na začátku vzít sluchátky k sobě, protože ten seminář bude překladaný do češtiny, do angličtiny i pro lesy ještě do polštiny. Jim budeme právě jeden příspěvek v polštině, tak bych vás poprosila vzít sluchátky k sobě. Jmenuji se Leonie Limich i pracuji pro nadaci Friedricha Eberta. Jsem velmi ráda, že uspořádáme tento seminář, odborný seminář, společně s konzorciem nevládních organizací pracujících s migranty v ČR, sociologickým ústavem Karlovy univerzity i s migrace online. Jak tady vidíte, za mnou je náš program Úterky u migrace. To znamená, tento seminář uspořádáme v cyklu debatu. A právě teďka, dneska už máme druhé setkání k tématům regularizace a vás očeká ještě další 3 zajímavé témata. Tak my srdečně vás pozveme na další setkání. Ale teďka ještě zpátky k tématům regularizace. Když jsme plánovali tento seminář, jsme chtěli právě podporovat tu diskuzi o aktuálních tématech tady v České republice. A několik lidí se zeptali, proč používáte právě terminologii regularizaci. My máme víceméně 2-3 důvody z toho. Jeden důvod je, že v mezinárodním kontextu se používá hlavně regularization. To je jeden důvod. Druhý důvod je, že právě terminologii jako nelegální, legální, legalizace a tak dále mají docela negativní konotaci a právě jsme chtěli tohle přeskočit. Tak jsme se rozhodovali na to, že regularizace bude terminologií pro naši dnešní seminář a právě chceme se soustředit na ten proces a nejenom na aktuální stav. A to jsou víceméně hlavní důvody, proč jsme se rozhodovali používat takovou terminologii. Dnešní program vás očeká první panel, to znamená, že tam chtěli jsme právě vám dávat mezinárodní perspektivu, zkušenosti na regularizaci. A právě z toho prvního panelu jsme chtěli vzít ty zkušenosti na české nebo na české úrovni a právě diskutovat v druhém panelu aktuální situace tady v Česku a vzít právě ty hlavní myšlenky z toho mezinárodního kontextu. Jsem velmi ráda, že Jana Leontievna bude moderovat ten první i ten druhý panel. Bohužel Marek Čánek onemocnil a není schopný tento první panel moderovat, ale jsem velmi ráda, že Jana Leontievna to převeze. Tak já vás přeju zajímavou diskuzi, zajímavé nové myšlenky a se těším právě na vaše názory. A teďka bych už hned předala slovo na Janu Leontievnu. Děkuji vám.
Dobrý den, jak již bylo řečeno, moje jméno je Jana Leontieva. Pracuji v sociologickém ústavu Akademie věd a už vlastně kolegyně naznačila, že původně tento panel měl moderovat Marek Čánek, kterýmu takhle, i když v jeho nepřítomnosti, si především poděkovat za to všechno úsilí, které vlastně naložil okolo organizace toho prvního panelu. A přiznávám se, že to je jako z velké části i jeho zásluha, i ta organizace, i ta účast těch hostů. A je nám samozřejmě velmi škoda, že tady nemohl být, protože má i trošku hlubší náhled do té evropské perspektivy. Nicméně, já se budu snažit v tom panelu, ačkoliv ta debata v té pozvance je uvedeno, že pracovním jazykem bude čeština, samozřejmě máte k dispozici tlumočení. Já se budu snažit v tom prvním panelu mluvit spíše anglicky. Jednak kvůli těm našim hostům, aby jsme nemuseli furt přepínat mezi jazyky čeština a angličtina. První dva příspěvky zazní v angličtině, ten třetí v polštině a jednak taky aby jsme i sjednotili nějaké termíny a tak dále. So, I will be speaking English in the first panel, so you don't probably have to have your headphones. And I would like to welcome here in the first panel our guests. We are very happy that all three of them came, because they represent three very different areas. Three very important actors. Although in the program you have Sebastian, the first speaker, today we decided that the first presentation will be given by Liliana Cave from organization, acronym of this organization is PITUM, is the platform for international cooperation on undocumented migrants. And this is the platform. Lesa will shortly introduce their activities, their work. And this is the platform which is very much engaged in lobbying for regularization, not only research, but also lobbying on regularization, also on the European level. Our second speaker is the representative of academia. Sebastian Chauvin is from the University of Amsterdam, the Institute for Social Science Research. So he will give us more deep insight, deep insight on the special aspect of regularization, also in European perspective. And the third speaker, we are very happy to have here the speaker who you don't see very often on conferences like this. Apart from the fact that Lesa is immigrant herself, and she's a representative of Polish NGO Nasz Wybór, Our Choice. This is the organization who were engaged in the process of regularization. And Lesa was personally engaged also, not only as a migrant who used this procedure, but also the one who lobbied for some changes. So we are very much looking to the presentation. I just would like to ask you if you have the questions which concerns some specific aspect of the presentation which you are probably afraid that you will forget at the end of the session, you are of course free to ask. However, I would like, because there will be a lot of informations and some of the questions will be probably answered in the further presentations, so try to keep your questions to the end. And we will have a floor for discussion at the end. Thank you very much. And Liliana, please, the floor is yours. This should work. This should work. Change it. Yeah, to change it, I don't computer, so this should work. Sorry. Yeah.
Which one? The middle?
Yeah, the middle, this one. Okay.
Hello, good morning. As Jana said, I'm Lilana Keith from PICUM. First, a few words about PICUM. It's the platform for international cooperation on undocumented migrants. We were started about 11 years ago by grassroots organisations in Belgium, Netherlands, Germany, who saw the need for a European-level organisation to be involved in the debates when they were developing the common European immigration and asylum policy. And so they developed a network really from the bottom up, and now we have more than 140 organisations, primarily in Europe, but also in other world regions that are a member of our network. We also have individual advocates who are members as well. The aim of the network is really to promote the respect for the human rights of undocumented migrants. We take a human rights-based approach. and try and give visibility to the reality that undocumented migrants are facing in Europe, paring away from the political discourses to what the real situation is. We do this through monitoring, research, advocacy, awareness raising and capacity building with our membership. Really trying to take the evidence from the members to the policy agendas. So that's a few words about us. So with this presentation, I just wanted to give a bit of an overview of how we see regularization and the issue within the broader frame. Our definition first of undocumented migrants is anybody without a valid paper for residence or employment. And there's typically very little information and data about this group because they are without paperwork, so it's very difficult. But there was a project called the Clandestino Project, which was funded by the European Commission DG Research, which tried to address this and gave an estimate back in 2009 that there was up to 3.8 million undocumented migrants in the EU 27. That may have gone down or up since 2009. They haven't had funding to continue the work, but it gives an idea. What else did they find in terms of pathways into irregularity? Why are these people without a valid residence permit? Most enter regularly, but their visa or permit has expired. Maybe they've lost their employment. The relationship has broken down. They may have applied for asylum but had it refused. They might be working without authorization, say if they have a student visa or something. Another key issue is bureaucratic failures. Long delays in processing applications, which mean that people fall out in the meantime. Irregular entry is another way, but it was found by the research to be the least common, in fact, of the way people become undocumented. And finally, also children, because they tend to inherit the status of their parent, even if they're born in the country of origin. They become an undocumented migrant, even though they have never migrated if their parents don't have papers. So what are the main mechanisms? What is contributing to this situation of irregularity across Europe? The lack of legal migration channels, meaning people don't have a possibility to come and work or join their family within Europe. Constantly changing and difficult to follow regulations and legislation, so you might even qualify at one point to be on a spouse-dependent visa, and then they change the rules in between, so when you apply for renewal, you no longer meet the minimum income requirement, things like this. Overcomplicated and bureaucratic procedures that mean that employers and individuals struggle to actually just meet the requirements. Strict conditions placed on the work and residence permits, that's like I mentioned already, something like a minimum income, which migrants might find it very difficult to meet. And large informal economies in many European countries, particularly in the south, where there is large amounts of employment opportunities that are informal. So this means that there's a demand for work, but it also means it's very difficult for migrants to regularize their stay and to get formal employment. So what are our conclusions from this? That some irregularity is inevitable, and it's a fact in Europe that there will be some undocumented migrants. Some migration laws and policies are actually the cause for irregular migration. This means that we need more channels for regular migration. We need to address the shortcomings and inefficiencies in migration laws that are causing these irregularities, these mechanisms that I have just highlighted, and provide mechanisms for people to regularize their stay, regularize their employment, regularize their residence. Another key point to raise in a conference like this is that they are a commonly used policy tool. A lot of policymakers talk about regularization as if it's like this rare thing which is very scary, but actually they're very common. If you look at the EU member states, there's been for 68 programs between 1973 and 2008, and 21 out of 27 have used some kind of regularization mechanism. It might have been on a small scale, but there's some kind of mechanism within these countries for migrants to regularize. It just makes sense. So what are the benefits? Why are member states' governments employing this sometimes scary policy tool? There are clear benefits from regularizations. It reasserts the state control and knowledge of the population. It enables protection of fair working conditions for all workers by regularizing employment. It recognizes the integration of undocumented migrants and their families, which is the reality in our communities and societies, that people are living and working and integrated, and making a very significant contribution, no less. It empowers migrants and their families to access their rights and services, living free from fear of detection and deportation. It also reduces their vulnerability to exploitation and abuse, because people, undocumented migrants, those with insecure status or no status, are very vulnerable because they have no or very limited access to justice. So they're very easy to be exploited by unscrupulous employers, landlords, smugglers, these kinds of people. It can also reduce inequality and social exclusion and lead to economic benefits through increased tax revenues, increased social security payments, this kind of thing. So what are the common criteria that have been used and are being used across the EU? Length and continuity of residence is a very common one. This could be a significantly long time. For example, in the UK, it's 20 years of continuous residence. It's 10 years if it's lawful residence, 20 years if it's any part of it was irregular. Proof of employment. I won't go into the details in specific because Sébastien Chauvin is going to go more into a few examples, but just to give an idea of what kinds of reasonings that people, that states are employing for having a justification to regularize. So proof of employment, local ties and integration, and this is often linked to children, for example, children attending school for a number of years, children having lived in the country for a number of years as well. There's also humanitarian reasons. These are things like very long asylum procedures. So somebody might receive the refusal of their application after they've already been living in Czech Republic for 5 years. Also things, health reasons and inability to return to the country of origin, because some people have their application refused, but still there is no safe route for them to go home. So there's increasing attention on EU level now also to this group of non-removables, they call them. So because legally they can't actually deport these people, yet they have no formal status in the country. Another key aspect is really human rights concerns. Medical reasons can be in that, because it could say that it would be a violation of human rights law, which prohibits any inhuman or degrading treatment. And so there has been cases in the European Court of Human Rights that have said, okay, you can't deport this person who has serious medical reasons to stay and they wouldn't have access to care, because that would be affecting their right to life. It would be inhuman and degrading treatment to inflict that on them. There's also a growing number of cases around the right to private and family life, and that's kind of similar to the local ties integration aspect. And the example I have here is in the UK, there used to be a 7-year concession for children. So it would mean that if it was like the length and continuity of residence, it was much smaller for children. It was only 7 years. They recently took that away, but they've argued that they're not actually taking away that rule, because Article 8, which is the right to private and family life, covers the same issues. So they're saying it's not linked now to 7 years arbitrarily. We're going to do an analysis at each point of the local ties and integration, the right of that child and the family to stay in the country. Another very important case was from the European Court of Justice, and so that's to do with EU citizen rights. It's called, it was Zambrano versus Belgium, and what it found basically is that if a child is an EU citizen, then an undocumented parent who is the sole primary provider for that child has the right to live and to work in the country of that child's citizenship. That's because then that would be depriving that child of their right to live in their country of citizenship if they would have to go to another country. Now, there's still a lot of work in the court of the various national courts are asking for clarifications and interpreting this in very different ways. But the case law is being developed around this right, which it doesn't affect many undocumented migrants, but there are an increasing number of kind of mixed status families where a child might have citizenship, and so that could affect the residence of their parent. Characteristics of regularizations. I listed before, I mentioned some benefits of regularization, but the particular characteristics of regularizations, which also hugely impact what the benefits can be. Different kinds are, there can be temporary and short-term regularizations, which are commonly discussed as programs. And they're for a limited amount of time, and they're reaching out to a large number of migrants under a specific criteria. So they're listing, and Sebastian Chauvin will give a couple of examples, specifically, okay, these are from 6 months, these are the criteria, these people can apply. Then there's permanent regularizations or mechanisms, which are really on a case-by-case basis. So, I mean, each of the criteria that I presented before, often when it's a program or mechanism, might be a combination of these, but some of these are permanent rules in migration law. A problem with those can be the level of discretion if they're not formalized properly in the law, and so it varies in different places as to how formal those ones are, if it's really done on a case-by-case basis. So essential considerations for both types, and whether they will be successful or not, is accessibility, and the bureaucratic, administrative and financial requirements. There are cases, for example, where on an employment reason, Italy said that you had to have a formal contract for employment for you to prove your current work in Italy, but obviously people were working informally, so how could they present this formal contract? Things like this mean that actually regularization programs might attempt to reach out to a large number of undocumented migrants and have very few applications or very few successful ones because the criteria are just too strict. The length and the type of residence permit granted is also essential. If it's only going to be a short-term 6-month or 1-year permit that's granted, then people are going to fall into irregularity again very quickly. It's not really a long-term change. The type of residence permit, I've said, because if it's linked then again to a specific employer, then again, people are going to be falling in and out of irregularity. Access to rights and services during the application process can also be very important for the lives of undocumented migrants in the process. And the clear criteria and information that's available about the process, about appeal rights, these are all essential considerations. So what are the recommendations? The Council of Europe Parliamentary Assembly has actually done a report and resolution a few years ago, specifically on regularization programs. I'm not going to go through each one because I think it's a lot of information, but it's linked to the characteristics that I've just outlined. So I'll just leave that for you to see, and then maybe we could share the presentation afterwards. But it's really trying to things around communication, accessibility, and ensuring the administration can actually cope and process regularizations. We would add a few as PICUM. And if I would pull out one, it would be that regularization, it should also be made very clear to applicants that a refusal of an application will not lead to immigration enforcement. We focus a lot of our work on access to services and any interaction with, and really we find that fear and any kind of mix between immigration enforcement and any provision of services or justice is the biggest barrier to undocumented migrants in enjoying their rights. And so the same is here for regularization. People won't access a procedure if they fear that then as a result, if they fail, they will get enforcement proceedings as a result. Again, accessibility, long-term and independent status, so that people are really empowered and not, able to have a long-term mechanism for keeping their regular status. An important point is the Council of Europe Parliamentary Assembly did also promote regularizations as a means of safeguarding the human dignity and human rights of particularly vulnerable groups of persons. So it's hopefully a little bit demystifying of what regularizations are and how practical they can be as a policy tool. I would end again on the conclusions I came to before, because as an organisation we highly value regularisation programmes as the Council of Europe recommends, but see that they will only still have a limited impact on the population of undocumented migrants. There needs to be also permanent mechanisms, there needs to be more regular channels, and there needs to be measures to really address these imbalances and these shortcomings in regular migration policy, which causes people to become undocumented. Thank you. And my contact details are there if you want to reach me.
Thank you, Lilana, very much. So, if you don't mind, we will continue with the next presentation.
Okay. Sorry. This microphone.
Yeah, that microphone.
Okay. All right. Thank you very much for having me here, and I'm humbled by the idea that I will represent academia. So don't take it literally. I'm not speaking for all my colleagues. Regularization is a strategic site for studying the role of employment in the political economy of migrant illegality, as its procedure distinguishes migrants who are considered deserving of legal status from those who are not. And this is the topic of my presentation today, work-based regularizations. Those work-based regularizations have been most prominent in southern European countries, albeit on a smaller scale. Some northern and new EU member states have regularized migrants, but more on humanitarian grounds and through the argument of family ties. A major reason for the continuous relevance of regularization is the continuing numerical significance of the irregular migrant population in the EU. Their numbers have been estimated at between 1.8 and 3.3 million in the EU 15 in 2008, which is a slight decrease, actually a significant decrease compared with 2002. Estimates vary because they're very difficult to come up with, at least in the case of Europe. Regularizations can be argued to be one of the main factors explaining the decline of the irregular migrant population between 2002 and 2008. My intervention today will examine employment as a condition for migrant regularization. Until now, most research on the relation between migrant illegality and work has focused on the effect of illegality and legalization on migrants' employment conditions. By contrast, the study that I'm presenting today is asking the reverse question, that of the effect of employment on migrants' access to legal status. Based on comparative analysis that I carried out with my colleagues Blanca Garces Mascareñas and Albert Kraler, I will focus on how policies construct different categories and levels of civic membership based on work. In particular, how employment has been framed in different regularization measures, whether as a condition for integration, as a way to enhance selective migration policies, or as a guarantee of economic deservingness. Now, the question of migrant deservingness has become more salient recently in Europe, with two connected processes regarding the institution of citizenship. On the one hand, what Willem Schinkel, a Dutch sociologist, called the virtualization of citizenship, by which he refers to the fact that migrants' civic worth, their value as a citizen, is increasingly put in question by dominant policy frames in contemporary European countries. So that citizenship tends to become ever more virtual in two senses. First, it is more precarious and reversible. It remains durably potential rather than actual. That's the idea of virtual in English. But second, it is even more contingent on the performance of virtue in the cultural, social, and economic domain. These are the two senses of virtualization. This is the first process. The second process is what my colleague Jan Willem Duivendijk, another Dutch sociologist, and his colleagues call the culturalization of citizenship, by which he refers to the gradual redefinition of citizenship in cultural terms and its new conditioning on cultural integration requirements in the case of migrants. And I will go back to that aspect. At first sight, work and employment may be expected to remain on the margins of such focalization of civic deservingness on cultural, ideological, or religious allegiance. However, as gainful employment, self-sufficiency, and the performance reliability within a precarious labor market are being defined as key civic duties within the current neoliberal context, they have increasingly come to be framed as cultural requirements themselves, so that work and employment are neoliberal cultural requirements. They're not just economic. And they figure prominently in policy literature as indicators of successful migrant integration, whether it deals with skilled or unskilled, first or second generation, legal or irregular migrants. Those constructions of deservingness within migration policy are not without contradiction, and I will mention two today. First, one about neoliberalism. As a regime of labor mobilization, sometimes summed up by the term workfare, neoliberalism has involved the construction of employment in general, and migrant employment in particular, as a civic obligation, one that sorts apart deserving from undeserving denizens of a country. But in contrast, restrictive and nationalistic politics of migration have led governments to increasingly present employment as a civic privilege, conditioned on pre-existing membership. Only citizens are allowed to work. Indeed, policymakers have often used such arguments to justify barring migrant access to legal employment. So an ambition of our research of the research we carried out is to examine the various ways in which this tension has been handled within policies and governments that purport to be both neoliberal and nationalistic. This is the first contradiction about neoliberalism. The second is about deservingness frames, what we call deservingness frames. By chiefly relying on a frame emphasizing civic performance, the criterion of employment as a source of regularization challenges the dominant framing of regularization that frames beneficiaries of regularizations as vulnerable individuals to be judged according to the urgency of their needs, and the severity of the dangers they face if returned. How do these deservingness frames interact in policy and practice? And this is what I'm going to tackle today. With this question in mind, I will first examine work-based regularization programs and mechanisms in Spain, France, and Austria. Then I'll discuss employment provisions in non-work-based regularizations in Belgium, Austria, and Germany, if I have time. These cases are taken as illustrations of the role of employment in the construction of migrant deservingness within two different regularization approaches. One is dominated by the civic performance frame, in which work is often central. You legalize migrants because they are good citizens. The other is dominated by the vulnerability and humanitarian frame, in which employment is in theory marginal. You legalize people because they're in a situation of need for care, not because they're performing citizens or non-citizens. The following case studies of Spain, France, and Austria reveal the variety of strategies that have been pursued in employment-based regularizations. Even if employment remains key to gaining citizenship rights in all three countries, they differ in the extent to which employment is framed either as individual virtue, as in the case of France, as proof of integration, as in Spain, or simply as needed, as in Austria. Whereas France and Spain represent different ways migrants' deservingness is judged on the basis of employment, in Austria the focus of the 2007 regularization of care workers has shifted to employers themselves, who had to prove that they themselves deserved their workers. In Spain, so first case, until 2001, the employment situation of applicants remained secondary, when required at all. In contrast to previous programs, the 2005 regularization was above all a regularization of workers, intended to combat irregular employment. The involvement of trade unions and employers' confederation in policy making for that legalization explained that shift. I can't get in detail here. The change in discourse was accompanied by a change in requirement. While proof of residence for several years continued to be a criterion, proof of employment became much more central. Employers now had to request the legalization of their workers at special offices. They had to extend an employment contract for at least 40 hours per week for a minimum of 6 months. And final authorization was conditional on registration in the social security system and payment of the first month's contribution to ensure that the employment bond was real and effective, and it was in the formal economy, not in the informal economy. The resulting permits were valid for 1 year and tied to a particular sector and province. Employers were thus at the center of the process, but they have accepted the role of labor unions in regularizing their workforce. By selecting, filtering, and approving applications in the name of both workers and employers, labor unions have played a key role in the implementation process. Now, I'm going to take the case. I can't get in detail into the source of legalization. I can go back to it through sort of general integration, arraigo social, or to integration in the labor market, arraigo laboral. I will leave it here. Now I can get to the case of France, which is a case I particularly investigated with a team of sociologists, from which we got this book. French governments of the decade 2000 pledged a tough stance on undocumented migrants. They extended controls on resident status to a broad range of welfare services, And they brought the annual number of deportations close to 30,000, which is very high internationally. Meanwhile, however, and that's the paradox of France, France regularized more than 30,000 migrants a year during the same decade, which is the exact same number as the number of deportation, whether on employment, humanitarian, or family basis. Employment was not absent in the legalization programs of the 1990s. Under a left-wing coalition government, the Jospin government, the two circulars from the interior minister from the time, Jean-Pierre Chevènement, in 1997 and 1998, legalized 80,000 undocumented migrants. These circulars already invited prefects to consider, and civil servants, to consider the existence of resources resulting from regular activity, along with the past fulfillment of fiscal obligations as elements of integration into French society. That is, migrants, undocumented migrants who had paid their taxes were considered more deserving already. But if employment played a role in the program, it remained both vague as a requirement and quite peripheral as a priority. A decade later, in the mid-2000s, the new conservative government, under President Nicolas Sarkozy, tentatively initiated a policy shift towards what he called chosen migration, a policy that privileged migrants categorized as economically desirable. In 2007, a new law allowed exceptional admission to residency for certain undocumented workers sponsored by their employers. The two government decrees stipulated how this law should be implemented. The first one gave nationals of new EU member states easier access to 150 occupations, while non-EU foreigners could only obtain legal residency through a list of 30 high-skilled occupations that varied from region to region. So unskilled occupations were reserved for basically white Europeans from new EU member states. But the undocumented migrants from sub-Saharan Africa had to be very high-skilled to get legalized. Those occupations, like expert computer programmer or sales representative, differed significantly from the jobs actually held by undocumented migrants in French society. Another decree stipulated that French prefectures could exceptionally examine applications for legalizations that match all other criteria, but are tied to a job that does not appear on the list. Seizing this opportunity, thousands of undocumented migrant workers, primarily in the cleaning and restaurant sectors, went on strike and occupied their workplaces in 2008 and 2010 with the support of the main French union, the Confédération Générale du Travail, CGT, demanding that their employers sponsor their legalization applications, even though they had not jobs that were on the official lists. About 5,000 were eventually regularized between 2008 and 2010 as a result of this mobilization. Regularization criteria were specified following negotiations between the CGT and the French government. Employment requirements became both more precise and more drastic than a decade before. Besides a job offer and proven years of presence in France, the undocumented migrants' history of formal employment became central for successful application. Although the government's granting of employment-based permits was presented by unions as recognition of the dignity of migrant work, these permits in fact gave migrants less freedom on the labor market than private and family lifeguards. They tied their holders to specific sectors and sometimes to specific employers, thus jeopardizing renewal in case of an unemployment or shift of sector. The dual imperatives of providing a work contract and having one's application sponsored by a single employer posed particular problems to mostly female domestic workers, working long hours for multiple employers, often on an undeclared basis. Nevertheless, work in many sectors came to qualify as a number of prefectures circumvented restricted job lists by resorting instead to labor market tests, whether there's a shortage in a given sector or not within a given region. Now, the problem was that those tests mechanically underestimated labor shortages in sectors where undocumented migrants were already working, because they were counting those migrants. They were refusing migrants to legalize in a sector because there was no shortage in that sector, because precisely those migrants were already working in that sector. In November 2012, the new Minister of Home Affairs, Manuel Valls, issued a new directive. Among other dispositions, it put an end to restrictive job lists, let migrants who had been working for more than 7 years in France get a temporary permit, even without a job offer, and officially allowed applicants to combine multiple part-time employment contracts to qualify. The latter measure, in particular, makes regularization potentially easier for domestic workers and other categories of precarious migrants, whose position on the French labor market was made more vulnerable by the economic crisis. Now, Austria, the case of Austria is interesting. It implemented a major, even though it's very anti-regularization, it did implement a major regularization program, targeting in particular categories of a particular category, of workers in 2007 and 2008, known as the care amnesty. Due to its focus on care workers, it may have involved a regularization of more than 9,000 persons. In stark contrast to the Spanish and French case, the deservingness of individual applicants for regularizations did not play a role. Indeed, it was employers rather than their care workers which were the actual targets of the program. It targeted the program concerned citizens of EU 8, the newly admitted countries, who did not enjoy full mobility rights under Austria's restrictive implementation of the transition rules for new EU members. The program just never applied to third country nationals, which arguably made it easier to justify. And of course, there's a racial aspect in this dichotomy between new EU members and third country nationals. The amnesty's main objective was to legalize existing informal employment practices without significantly increasing the costs of employing care workers. The new job profile that was created entailed lower minimum wage for employed workers and no minimum wage for self-employed ones, which made up 97% of the workers legalized, thus instituting a neoliberal model of deregulated employment, which was quite exceptional within the Austrian labor market. Care workers themselves were largely absent from the debate in the care amnesty. The issue was not whether individual migrants deserved to benefit from the amnesty, but whether their clients, families, and their members in need of long-term care deserved access to affordable services. Thus, here, the notion of deservingness was put on its head. Now, in a few minutes, maybe 3-4 minutes, I will examine the second aspect of work in legalization procedures, which is the role of work in officially non-work-based legalization. In particular, humanitarian legalizations. Now, humanitarian regularizations are rooted in national, but also European and international human rights law, as has been said already. For this reason, they differ from work-based legalization in their degree of judicialization and Europeanization through various the European Convention of Human Rights and the role of the European Court of Human Rights. In particular, the Article 8 of the European Convention of Human Rights, which focuses on family ties. family ties, and length of residence, which have frequently been considered. Other humanitarian grounds on which individuals may be regularized include medical reasons, the right of children, and integration into host societies. Here I'm particularly interested in integration. The growing recognition of integration, including but not limited to labor market integration, as a potential source of legality for humanitarian legalization, can be observed at both national and European levels. At the European level, the European Court of Human Rights usually frames integration in terms of ties to the host country. While the court has long recognized family ties to legal insiders, legal migrants, as a potential source of legality, or at least grounds for preventing expulsions, recent case law has extended the notion of private life to include, I quote, the network of personal, social, and economic relations that make up the private life of every human being, thus opening the door to using employment as a source of legality. The Council of Europe has followed this line of thinking in promoting the notion of earned legalization, earned regularization. Essentially, earned regularization is based on the idea that migrants' de facto integration, including in employment, should be rewarded. In the Council of Europe's proposal, this would be within formalized point system. Quickly, I want to mention three case countries, Belgium, Austria, and Germany, which represent slightly different policy responses in regard to a particular subgroup of irregular migrants, rejected asylum seekers who have not returned. Belgian practice is close to the European Court of Human Rights, in that employment is a supportive factor in deciding a case, neither a condition nor sufficient in itself to grant or deny regularization. A major regularization program in 2009 departed from previous practice by offering two specific streams for applicants that are able to prove durable local integration, ancrage local durable. Both streams gave significant weight to employment. The first stream required general proof of employability rather than actual employment, alongside other criteria such as language proficiency in one of the official languages of Belgium. The second stream effectively amounted to work-based regularization and required applicants to have a job contract and 2 years of residence, of previous residence. This is for Belgium. Now for Austria, regularization on humanitarian grounds was first introduced in the 1997 Aliens Law. In 2009, a new legal framework was adopted that gave rejected asylum seekers the possibility to apply for residence permits on the ground of long-term residence and de facto integration. As part of the requirement to prove integration, applicants under this option must not be a public burden and show either an employment contract or produce a declaration of sponsorship by a natural or legal person. The paradox is that access to legal employment for asylum seekers remains exceptional. It largely depends on the favorable use of discretionary powers by regional and provincial labor and immigration authorities during the required labor market tests. Most asylum seekers are therefore not granted access to work. If they are, work permits are usually allowed to expire or withdrawn upon the final rejection of an asylum application. Ultimately, employment conditions in humanitarian regularizations appear as caricatures of earned legalization, where only those who, against all odds, gain access to legal employment are rewarded with legal status. Now, the last case I examined is the one of Germany, with the particular case of the Duldung. In Germany, the Duldung is a temporary suspension of removal. It's been the standard response to the prolonged presence of irregular migrants. Like for asylum seekers in Austria, tolerated persons have reduced access to employment in Germany. They're obliged to reside in particular districts which affect their employability. In 2007, Germany offered a type of earned legalization that tolerated persons with families who had stayed in Germany for at least 6 years, and for other tolerated persons who had been in Germany for at least 8 years. To benefit from the program, applicants had to show proof of employment and sufficient income. Given the restrictions on movement and labor market access, few applicants were able to do so. Applicants without work at the time were given temporary permits to find work, initially valid until 2009 and then extended to 2011. Once again, in a country that is very much against legalization. It's actually interesting. I'm going to conclude now. So these few focal cases that I've examined today have shown that the role of employment in regularization needs to be examined not only within regularization programs and mechanisms officially based on work, but also, more broadly, within policies that frame social integration and ties to the host country of residence as key elements of earned legalization. Up until now, what I called in the introduction the virtualization of citizenship, that renders full membership in a society more precarious and contingent on performance of civic virtue. This virtualization of citizenship has been deployed in Europe mostly in ways that question the civic worth and of legal migrants and their descendants, in particular Muslim migrants. Muslim migrants possessing residence permits and even citizens have been told that citizenship resides in more than just papers, but in good behavior, cultural assimilation, and subjective identification. It's not enough to have papers. But how long can the idea that citizenship is not just about papers be promoted for restrictive purposes without extending it in some way to precisely these residents who do not yet have papers? In his seminal analysis of the long-term emergence of citizenship in England, Thomas Marshall showed how civil rights historically were won first, followed by political rights, and finally, in the 20th century, the social rights associated with the welfare state. Ironically today, the type of earned citizenship pressed upon irregular migrants invites them to use their social, economic, and labor integration to claim rights more traditionally associated with core civic membership, in effect turning the historical emergence of citizenship on its head. Nevertheless, exhibiting one's integration into society or deservingness is but one way to claim rights, one which often clashes with the still dominant framing of the beneficiaries of regularization as vulnerable individuals, not integrated individuals. In contrast, employment provisions follow a civic performance frame, largely breaking with the criterion of vulnerability. Potential conflicts between these frames need to be further studied, especially when conflicting frames successfully prevail as conditions for being tolerated first, and then getting regularized maybe a year later, or even having one's permit renewed. Finally, the valorization of employment can present opportunities for migrants, especially in times of economic growth. But the same logic can turn into a system of exclusion during recession or crisis. Indeed, while work-based regularization and renewal requirements generally privilege people with secure employment paying standard wages at the expense of those under more precarious or informal conditions, the current economic downturn has made stable jobs even less accessible to migrants seeking to regularize or maintain their legal status. Legal status thus grows more precarious itself, often involving repeated transitions in and out of illegality. A vicious circle of disintegration threatens to set in, by which employment precariousness becomes both the rising source and the dire consequence of legal precariousness. Thank you.
Thank you, Sebastian, for very interesting presentation. So the last presentation in this panel will be from Lesa Kostia. Kółeczką переключаєш, цим червоним просто вносиш.
Dzień dobry, Szanowni Państwo. Nazywam się Lesia Kostina. Z pochodzenia jestem Ukrainką. Obecnie mieszkam w Polsce 8 lat. Z 8 lat, których przeżyłam w Polsce, 7 lat byłam w statusie nielegalnego migranta. Z tego powodu był taki pomysł o abolicję, bo coraz częściej spotykało się kolegów lub koleżanek w transporcie, w różnych takich miejscach publicznych, z którymi staraliśmy się integrować i coraz więcej słyszeliśmy, że bardzo dużo osób mają nieuregulowany status. I właśnie z tego był wzięty ten pomysł na abolicję, jak zamienić regulację prawną i doprowadzić do sytuacji, w których migranci przebywający w Polsce nielegalnie mogą zalegalizować swój pobyt. Pierwsza taka rzecz, na którą my zwróciliśmy uwagę, że musieliśmy po prostu zbadać społeczeństwo polskie, czy ono jest otwarte na migrantów. Z tego wynikało następne. Zrobiliśmy takie badania wśród swoich znajomych i nie tylko znajomych, w którym po prostu zbieraliśmy podpisy, czy społeczeństwo polskie wyraża zgodę na to, żeby zalegalizować migrantów w swoim kraju, którzy przebywają nielegalnie. Było zebrano bardzo dużo podpisów. Tysiące podpisów świadczyli o tym, że jednak społeczeństwo polskie jest otwarte dla migrantów i chcą tej legalizacji, ponieważ między migrantami, którzy przebywali w Polsce nielegalnie, bardzo dużo osób było wykształconych i mieli takie profesje, które byli po prostu zapotrzebowane na polskim rynku pracy. No i kiedy zaczęła się ta akcja abolicyjna, mieliśmy bardzo dużo różnych takich atutów, z którymi po prostu których chcieliśmy pokazać społeczeństwu, że my też jesteśmy ludźmi, chociaż mamy status nielegalny, ale jednak jesteśmy też ludzi, którzy mamy prawo do godnego życia. Nie możemy ciągle żyć w strachu przed deportacją. Chcemy też, żeby Polska skorzystała z naszych umiejętności. Chcemy żyć legalnie, płacić podatki i mieszkać w tym kraju bez strachu. Pierwsza rzecz, z której my zaczynaliśmy kampanię abolicyjną, był to list, który był napisany do Fundacji Rozwoju Oprócz Granic. To była fundacja, która bardzo aktywnie podtrzymuje migrantów i pomaga w różnych sytuacjach życiowych. W tej fundacji pracują szczególnie migranci, też którzy pochodzą z Białorusi, z Rosji, z Ukrainy. Też wśród pracowników fundacji była dziewczyna pochodzenia polskiego, która była naszym koordynatorem medialnym w czasie abolicji. Bardzo długo był przygotowywany ten program z którym my chcieliśmy wystąpić do rządu polskiego, żeby pozwolić na godne życie migrantom, którzy przybywają w Polsce nielegalnie. Napisaliśmy list otwarty do prezydenta, marszałka Sejmu i Senatu, do prezesa Rady Ministrów. No i do tego listu byli dołączone też nasze podpisy, byli dołączone też pakiet dokumentów, który wskazywał na to, że z abolicji, która była przeprowadzona w 2007 roku, skorzystało tylko 80 osób, było tylko 80 wniosków, więc skorzystało 11 osób tylko skorzystało z tej abolicji. Więc zmiana przepisów tutaj była konieczna i my postanowiliśmy po prostu przełamać tą barierę i wystąpić o to, żeby złagodzić te przepisy. Więc abolicja, która odbyła się w 2012 roku w Polsce, była jakby takim wielkim zwycięstwem migrantów, szczególnie tych, którzy przybywali nielegalnie, tylko dlatego, że te migranci nielegalnie potrafili wystąpić o swoje prawa i które skończyły się zwycięstwem. Myśmy prosili rząd polski, żeby zniósł nam przepisy, które dotyczyli terminu przebywania nielegalnego imigranta na terytorii Polski, ponieważ z abolicji 2007 wynikało, że migrant mógł składać wniosek o abolicję, który przybył na terytorium Polski 10 lat. Powinien był mieć prawo do pracy, zameldowanie oraz tytuł prawny do lokalu. Jeżeli popatrzeć z takiej czysto ludzkiej strony na tą sytuację, to nie każdy, powiedzmy, tutaj ja mówię o Polsce, nie każdy Polak ma prawo tytułu prawnego do lokalu lub umowy o pracę, a o migrantach tutaj w ogóle nie może być i mowy. Dlatego byli zniesione te przepisy i nam pozwolili zalegalizować swój pobyt, tylko udowadniając pobyt na terytorium Polski, nielegalny pobyt na terytorium Polski 5 lat. Dlatego był potrzebny tylko paszport jako dowód tego, kiedy człowiek przyjechał na terytorium Polski. Czasami nawet byli takie przypadki, że ludzie, którzy nie mieli paszportów, dostawali się przez zielono w granicę. To wystarczyło tylko dowodu, powiedzmy, że ktoś skorzystał z jakiegoś urzędu, był u lekarza, powiedzmy, czy cokolwiek, co usprawiedliwiało i udowadniało to, że ten człowiek z tego czasu był w Polsce, już na ten czas był w Polsce. No i jeszcze chcę powiedzieć taką rzecz, że kiedy my mieliśmy jeszcze takie szczęście, że u nas w Sejmie jest taki poseł, który od mniejszości narodowej, i właśnie on jest przewodniczącym Komisji Mniejszości Narodowych i Etnicznych i jest pochodzenia ukraińskiego. On bardzo dużo pomógł nam w czasie walki o tą abolicję. Też różnymi drogami legalnymi, jak i nielegalnymi, też konsultowaliśmy tą ustawę abolicyjną z doradcą prezydenta Bronisława Komorowskiego, Henryk Wujec, który bardzo dużo pomógł nam w tej drodze o abolicję. Droga do tej abolicji była bardzo długa. Cała kampania trwała ponad 2 lata I bardzo dużo organizacji było wspierających nasz pomysł. My organizowaliśmy taki komitet, który miał nazwę Migranci na rzecz abolicji, który składał się szczególnie z nielegalnych migrantów. Założycielką tego komitetu była ja razem z koleżanką, ponieważ cały ten pomysł nasz wynikał z tego, że my każdego roku w Sylwestra nasze życzenia byli jednakowe, że w tym roku już chcemy pojechać do domu i zrobimy wszystko, żeby po prostu następny rok już świętować ze swoimi rodzinami. Cały nasz komitet był odpowiedzialny za planowanie tej całej kampanii, przygotowywanie materiałów dla mediów, organizowanie różnych konferencji, debat. I w Polsce był nagrany taki film, który chyba jeszcze do tej pory jest na YouTubie. On ma nazwę Nielegalni migranci w Polsce. To była jedna z metod nagłośnienia tego problemu, bo tak naprawdę szefowa naszej fundacji FROK, która bardzo aktywnie podtrzymywała naszą kampanię, była zaproszona do Europejskiego Parlamentu z powodu właśnie tego problemu w Polsce i większość posłów w Europarlamencie byli bardzo zdziwione, że w Polsce w ogóle są nielegalni imigranci i oni mają taki problem. Ale nielegalni migranci są w każdym kraju, nie tylko w Polsce. Jest oni w Czechach i w Niemczech i wszędzie. I my czasami, szanowni państwo, zapominamy o tym, że to są tylko zwykłe ludzie. Może oni nie są obywatelami tego kraju, ale tylko z tego albo innego powodu oni byli zmuszeni czasem przyjechać do tego kraju, żeby po prostu podtrzymywać swoje rodziny, bo patrząc na ten problem ze swojego doświadczenia, to ja przyjechałam do Polski tylko dlatego, że nie mogłam poradzić sobie w swoim kraju, mając wykształcenie ekonomiczne. Straciłam pracę, a 2 dzieci trzeba było po prostu wyżywić, posłać do szkoły i wykształcić. I właśnie ten problem jest u większości osób, które przyjeżdżają do kraju i zostają tam nielegalnie. W czasie trwania tej naszej abolicji była uruchomiona strona, która była nazywana petycja.pl. Pod tą petycją bardzo dużo było zbierano podpisów, czy polskie społeczeństwo chcą migrantów, czy oni są otwarci na migrantów, czy nie. Było bardzo dużo podpisów za, też byli podpisy przeciw, bo niestety nie wszyscy są nastawieni do migrantów przyjaźni. Czasami, jeżeli ktoś usłyszy słowo migrant, to jemu się od razu kojarzy, że jest to jakiś bandyta albo jakiś terrorysta, który przyjeżdża do kraju i po prostu chce tam wszystko zniszczyć. Ale czasami też my zapominamy o tym, że jeżeli ubudzimy się jednego dnia w swoim kraju bez migrantów, czy będą pracować nasze budowy, czy u nas wszyscy przyjdą do pracy, zostawiając swoich rodziców bez opieki, czy swoich dzieci, czy będą posprzątane nasze domy, czy będą posprzątane nasze hotele. Mogę powiedzieć, że ja drugi dzień mieszkam w Pradze i w hotelu, w którym mieszkam, spotkałam też migrantów z Ukrainy, którzy sprzątają ten hotel już nie pierwszy raz. Ale tak naprawdę my też nie wiemy, czy oni są legalnie, czy oni są nielegalnie, bo oni nie powiedzą o tym. I wychodząc powiedzmy do miasta, bardzo często słyszy się język rosyjski, ukraiński. Więc to są wszystko migranci, ale tak naprawdę my nie wiemy, jakie oni mają problemy. To są zwykle ludzie, którzy chcą pójść do lekarza, którzy też muszą skorzystać z jakiegoś urzędu i oni mieszkają dość często w ciągłym strachu i po prostu boją się wychodzić, boją się kontaktować z innymi ludźmi, zero integracji ze społeczeństwem, powiedzmy czeskim, bo oni ciągle mieszkają w strachu. Był też uruchomiony u nas blog, który nazywał się Jestem za. Logiem tego bloku było takie zielone jabłuszko, które ja mam u siebie. Pomysł na to jabłuszko był wzięty z tego, że bardzo dużo migrantów, którzy przybywają do Polski z Ukrainy, Białorusi lub Rosji, pracują szczególnie w rolnictwie. Zbierają jabłka, zbierają truskawki. No, oczywiście, że jeszcze pracują na budowach, budują domy, budują drogi, budują wszystko, ale właśnie to zielone nasze jabłuszko to było naszym logiem. My pokazaliśmy, ile osób pracuje w rolnictwie. Jeżeli były takie dane, ja już w tej chwili nie pamiętam tak doskonale, ale ponad 70% zatrudnionych w rolnictwie w czasie zbierania tam różnych owoców lub warzyw, to były osoby z Ukrainy. Nasza kampania jakby ta abolicyjna zaczęła się 26 listopada 2010 roku. No, kiedy my złożyliśmy już te wszystkie dokumenty do prezydenta, Sejmu, Senatu, premier-ministra i to wszystko po prostu zrobiła się nagle cisza, było cicho, nikt o tym nic nie mówił. I pewnego dnia my znowu spotykaliśmy się ze swoimi koleżankami i postanowiliśmy spytać u rządu, co z tą abolicją, gdzie jest nasz projekt abolicyjny, dlaczego jest taka cisza. No pewnego dnia, ja pamiętam, to był dzień 26 sierpnia 2011 roku, ja zawsze wychodzę do pracy, wstaję bardzo rano, wychodzę do pracy też rano i oglądam pierwsze wiadomości. Włączając pierwsze wiadomości, usłyszałam, że dziś prezydent podpisuje ustawę abolicyjną. Strasznie się ucieszyłam, bo naprawdę byłam po prostu przerażona tym faktem, bo była konkretna cisza, nikt o tym nic nie mówił. No i skończyło się tym, że 26 sierpnia 2011 roku prezydent Rzeczpospolitej Polskiej Bronisław Komorowski bardzo podpisał ustawę abolicyjną. Na podpisanie tej ustawy było bardzo zaproszono dużo różnych fundacji, przedstawicieli mniejszości narodowych, które walczyli o tą abolicję. I właśnie to zdjęcie, które jest teraz wyświetlone, to jest po zakończeniu już po podpisaniu tej ustawy, to jest Ksenia Naranowicz z Fundacji FROK, no i ja oczywiście na konferencji prasowej po podpisaniu już tej abolicji. No, zielone jabłko, jestem za to, ja już mówiła. I jeszcze głównym naszym atutem w walce o abolicję to było zalegalizowanie osób, dlatego żeby mogliśmy legalnie pracować, żeby my mogliśmy wyjść ze szarej strefy, ponieważ migranci, którzy przybywają w kraju dość długo, ponad 5 lat, nie tylko ponad 5 lat, niektórzy mniej, niektórzy więcej, ale oni już mają tą pracę i ich nie trzeba sprowadzać już do tego kraju. Oni mają podłoże, na które po prostu mogą liczyć. Wystarczy tylko zalegalizować tych migrantów, żeby oni mogli płacić te podatki. No właśnie tutaj jest pokazane zdjęcia z 26 listopada 2010 roku, kiedy my wyszliśmy przed Sejm i bardzo aktywnie walczyliśmy o abolicję i głównym naszym takim banerem było takie dajcie zielone światło dla abolicji. Też po tym odbyła się konferencja prasowa, na którą byli zaproszeni różne przedstawiciele. Byli profesorowie z Uniwersytetu Warszawskiego, pan poseł Mirosław Sycz, Ksenia Naranowicz i wiele innych osób. Więc profesorowie z Uniwersytetu Warszawskiego, co było dla mnie bardzo śmieszne, po prostu stwierdzili, że nie chcemy migrantów, oni nam nie są potrzebni, ale oni zapominają o tym, że migranci bardzo aktywnie pracują na ekonomikę polską, na gospodarkę polską, bo tak naprawdę, jeżeli patrząc się z tego punktu widzenia, to bardzo dużo Polaków wyjeżdżają do Niemiec, do Francji, do Anglii, które też pracują tam i nie zawsze oni pracowali, czy pracują legalnie, a ponieważ my przyjeżdżamy też do Polski po to, żeby też jakoś sobie poradzić na rynku pracy, ponieważ my nie możemy w swoim kraju znaleźć takiej pracy, za którą moglibyśmy normalnie żyć. No. Mogę jeszcze powiedzieć taką rzecz, że bardzo dużo w czasie abolicji było nagłośnień medialnych. Ponad 94 udokumentowanych relacji radiowych i telewizyjnych oraz zaproszenie do studia. Ja osobiście byłam w studiu telewizyjnym od razu po wystąpieniu pod Sejmem i tak naprawdę ja tylko teraz się zastanawiam, jak po prostu ja mogłam wtedy nie bać się, po prostu normalnie pójść i pokazać się w telewizji, ponieważ już wtedy byli moje dzieci w Polsce, które studiowali i byli legalnie i dla mnie już tak naprawdę było wszystko jedno, bo ten problem już był tak nabolały, że trzeba było coś zmienić, bo bardzo dużo ludzi, którzy przybywali na terytorium Polski nie tylko z Ukrainy, a i z Wietnamu, i z Pakistanu, i z Iranu, byli bardzo długo nielegalnie. No bardzo dużo też stacji telewizyjnych na Facebooku, bardzo dużo pisało. Była uruchomiona też strona oficjalna rządowa, która nazywała się abolicja.gov.pl i na tej stronie można było też pisać swoje pomysły, czy chcemy migrantów w swoim kraju, czy nie chcemy migrantów, jak my traktujemy, czy jesteśmy za to, żeby ich zalegalizować, czy nie chcemy ich legalizować. I mogę powiedzieć jeszcze taką rzecz, że my walczyliśmy o co było problemem w całym społeczeństwie. Dlatego nam była potrzebna bardzo wielka grupa wsparcia, którą my potrafiliśmy zorganizować, będąc nielegalnymi migrantami. Wokół siebie my stworzyliśmy taką grupę, która zrozumiała nasze problemy i chciała nam po prostu pomóc. I też, żeby opracować strategię tego problemu, to musieliśmy współpracować z różnymi ludźmi. Czasami byli to nasi koledzy, koleżanki lub kolegi naszych kolegów, którzy po prostu też w sposób nielegalny potrafili nam pomagać. No i to wszystko, co chciałam Państwu powiedzieć, bo ponieważ chcę zaoszczędzić czas jeszcze na debatę. Jeżeli będą jakieś zapytania, to bardzo proszę. Dziękuję za uwagę.
Thank you very much, Lesia. Actually, thank all three of you, for your presentations. I'm sure there were a lot of very interesting information. This panel was very informative. And probably before we started a bit later, so let's say we will have like 20 minutes, depending on how many questions you will have for discussions. So now the floor is yours. It's important to keep in mind that we have translations, so please wait for my colleague to approach you with a microphone, so that all our guests understand your question. You can, of course, speak both Czech and English. So, do you have any questions? Or because I have a lot. So, I should probably start. Oh. Okay, so we have a first question over here.
Scott, já bych měl dotaz na všechny přednášející, ale především na paní Kostinu. Zajímalo by, do jaké míry vám pomohly při těch snahách o abolici polské odbory. To je první otázka. Druhá otázka je, do jaké míry měla abolice vliv na integraci migrantů do té míry, že se stávají, bych řekl, trvalými občany Polské republiky. Případně tady by mě zajímalo porovnání i s ostatními zeměmi. To bych se ptal na kolegu Šovina a na paní Kejtovou. Že? Děkuji.
Děkuji, my asi budeme, protože to je velmi rozsáhlá otázka, tak asi já dám možnost odpovědět a pak budeme pokračovat. So,
Związki zawodowe grają bardzo wielką rolę w walce o naszą abolicję. Tak jak ja powiedziałam, że bardzo dużo fundacji formalnie, legalnie lub nielegalnie podtrzymywali nas w czasie abolicji, ponieważ my musieliśmy wszystko prawnie, bardzo dokładnie, prawnie sformułować swoje zastrzeżenia i swoje problemy, które odróżnili abolicję 2007 od abolicji 2012. I sami my to nie mogliśmy zrobić, ponieważ my mieliśmy bardzo dużo konsultantów, o których ja nie powiedziałam tu. I tutaj szczególnie bardzo wielką rolę grali związki zawodowe. I jeszcze o integracji migrantów. Tak, migranci bardzo dużo wygrali w tej abolicji, ponieważ było złożono 9555 wniosków i większość osób dostali pobyt, dostali zezwolenia na zamieszkanie w Polsce. Większość z nich mają teraz pracę legalną, pracują legalnie, pracują w ustanowach państwowych oraz bardzo dużo jest zatrudnionych też w gospodarstwach domowych. Więc integracja z społeczeństwem, oczywiście my zawsze podtrzymywaliśmy też różne akcje, które były przeprowadzane w Polsce. Integrujemy się z polskim państwem, ponieważ my mieszkamy w tym kraju i wszyscy problemy polskie też dotyczą nas, pomagamy w różny sposób w różnych problemach. Po prostu my o tym tak szeroko nie mówimy. O takie rzeczy są opisywane w naszej gazecie, o której ja nie powiedziałam, bo ja pracuję jeszcze charytatywnie w Fundacji Nasz Wybór, która ma swoją gazetę w Polsce i jest refundowana z Funduszu Unii Europejskiej na rzecz integracji państw obywateli trzecich. I właśnie o tych różnych takich problemach my opisujemy w swojej gazecie.
Thank you, Lesia. Thank you, Lesia. So probably Sebastian and Lilana could also comment on the on how trade unions were incorporated in this regularization.
Well, for other country cases.
Yes, for the other country. Yes, for the other country cases.
Yes, I mean I can use the case of France again. In the 1990s, labor unions were not opposed to regularization. They were actually a lot of them would actually support struggles by undocumented migrants, but they would support it mostly as external forces. They would consider this to be a civil society issue that did not have labor implications. Only, I'm making a simplification here, but let's say only in the decade 2000, these unions, and in particular the CGT, decided to make it a labor issue, a labor rights issue, and started to frame undocumented migrants primarily as workers that needed to get full rights as workers, and in order to get full rights as workers, needed to be regularized. So they incorporated the fight for legalization as a labor issue, and not just as a civil rights issue that a labor union should, a humanitarian issue that the labor union should support externally.
Yeah, I think Sebastian Jourdain has answered in terms of trade unions. The only thing I would add would be on the question of integration after regularization, to say, as I tried to point out in the presentation that I gave, is that it is very dependent then, following a regularization, dependent on the characteristics of the regularization that was carried out. And I think what Lesia illustrated well is how they really tackled the shortcomings in the previous regularization and defined very clearly the terms so that it could be a sustainable and accessible regularization, which was much more successful in the recent one compared to other examples where it hasn't really empowered workers or migrants to improve the situation because they've been dependent on employers. It's been short-term statuses, which means that they're still vulnerable to exploitation, they're still working under poor conditions where their labour rights aren't being protected. There's always access to services and rights, and as you were describing, the lack of fear of deportation, which is obviously a huge part in then the integration of migrants into the societies after regularization, but these issues do continue. So.
Thank you very much. It was a very interesting question. I also had that in my list because I think that the problem of sustainability of the status, of how much those immigrants who got the chance to remain in the country and to get the appropriate paper, how much they can use the opportunities they are offered, and if there's a certain risk, because of course in the first panel at least I had a feeling that we were speaking more about positive aspects, but we were not speaking about some concerns. And if there's a concern, because it also go along with the previous question, if there are some concerns that one measure is not enough for an immigrant, that they can fall into illegality again. So probably you can also shortly comment on that, and then we again give the floor to the audience. Thank you.
Yes, definitely there is a tendency in making new residence titles more precarious and shorter. And to a part, to an extent, the focus on employment in particular is a way of, or goes with this shift towards more precarious residence titles. We are actually seeing something that looks like this in the United States at the moment, which is comparatively much more generous than European states in terms of legalization. But still, now the United States is considering shifting logic of legalization from those based on family ties to a logic based on merit and deservingness, as the one I described. And as in Europe, the new titles, new residence permit that they offer, that they're actually elaborating at the moment, are short-term. And the pathways towards full legality or permanent residence are becoming longer and more uncertain.
Okay. So, Lisa, would you like to comment on this? The microphone.
Nie, uważam, że koledzy już dostatnio wyczerpali to pytanie. Dziękuję.
So I will give a floor to you again, if there are any further questions, please.
Dobrý den, já jsem Akademické. Já bych se chtěla zeptat na jednu věc. Já jsem vlastně zpracovávala téma regularizace do diplomové práce. Zase nějakou dobu, bohužel ty tématy jsou hodně aktualizované, takže už mám víceméně nastudovaná stará data. Nicméně jsem se chtěla zeptat na váš názor. Já jsem v rámci té práce tenkrát dělala takový mini průzkum a sledovala jsem hodně aktéry v rámci České republiky ohledně regularizace. A byla jsem na ministerstvu vnitra, kde jsem hovořila vlastně na odboru azylové a migrační politiky s zástupci. A tak v České republice je hodně známo, že vlastně ministerstvo vnitra je striktně proti regularizaci. A jako hlavní argument mi udali vlastně obavu českých úřadů z navýšení migračních, vlastně ilegálních migračních toků do České republiky po regularizační, po nějaké regularizaci. Tak jsem se chtěla zeptat na váš názor. Jestli máte například z vašich výzkumů nějaké opodstatnění této obavy, jestli třeba docházelo k nějakému nárůstu po regularizaci. Asi zřejmě otázka na všechny tři. Jenom stručně stačí.
You can start, Lisa.
You can start.
Oh.
Yeah.
I mean, it's really to turn it on its head. I mean, there's no research, there's no data showing that there is an increase in numbers. And normally, because there are these conditions, it's not for somebody who's just arrived that they can then apply for regularization. When there are these programs, they tend to have various criteria that have to be met. So as long as that's well communicated, there's no indication that that's actually based in any evidence. Maybe you can.
Yeah, no, there's very little evidence, but one thing that could be noted is that a lot of today's pathways into irregularity are from people who have been legal, they're legal, and they have trouble adjusting their status. They fall back into irregularity because, for example, they're students and then they fail 1 year and then they end up into irregularity. In a sense, a lot of these people wouldn't have become illegal 30 years ago. They have become more illegal because of the change in legislation. So that the main origin of this illegality is migration law, and it's tightening. Yeah, sure, I'm not doing this. So, you know, it's a more general. It may be a part of a more general debate on borders and what would happen if there were no borders. We don't know. Some people say that. If borders were easier to cross, it would be like it used to be, which is circular migration. People come and they would leave, and a lot of the reason why people stay is because they know that they can't come back if they will have trouble to come back if they leave. Actually, when people get legalized, in French case, but I know it's true of other cases, the first thing that you do when you're legalized and you haven't been able to go see your family for so long is you leave. The first thing you do when you legalize is you leave. Sometimes you leave for 2 months because you haven't seen your family for so much time. So the idea that when you have a more liberal migration system, people stay is complex.
Lesio?
Ja chcę jeszcze dodać następne, że po niektórych danych Straży Granicznej szacowało się, że w Polsce może przybywać ponad 50 000 nielegalnych migrantów. Ponieważ byli to dane Straży Granicznej, oni głównie byli bazowane na tym, że te osoby przekroczyli granicę, ale nie tylko w jedną stronę. Więc mogę powiedzieć, że w czasie trwania abolicji za tych pół roku bardzo dużo wyjechało migrantów nielegalnych z Polski, więc teraz nie słychać o takich problemach, czy nie spotykamy tyle różnych problemów, które są związane z nielegalnością. No uważam, że nielegalni imigranci oni zawsze byli i będą w kraju i tak naprawdę ich bardzo ciężko policzyć, ale żeby po tej abolicji był wzrost migrantów, to ja też nie jestem tego pewna.
Thank you very much. Any other questions from the audience? Okay, please, Eva.
Dobrý den, Adonala. Já bych jinak chtěla pogratulovat iniciativě, kterou tady prezentuje paní Kostina. Se mi to moc líbí, že to je takový jako grassroots. A chtěla bych se zeptat, jakým způsobem se vám vlastně podařilo migranty v nelegálním postavení zapojit. Jak jste vlastně překonali ty bariéry, že se nebáli a aktivně vystupovali a kolik lidí v tom neregulárním postavení se v Polsku zapojilo do té iniciativy.
Dziękuję za zapytanie. Tak naprawdę inicjatywa tej abolicji to była moja inicjatywa i wynikała ona z tego, że ja bardzo chciałam pojechać do domu, żeby spotkać się ze swoją rodziną. Przepraszam. I my potrafili wokół siebie zgromadzić pewną grupę, szczególnie nielegalnych migrantów, takich, którzy byli aktywni i którzy po prostu nie bali się, że będą zauważeni przez policję, przez straż miejską. Po prostu byli to osoby bardzo aktywne, byli to osoby takie, którym było wszystko jedno, tak jak mnie. Czy ja pojadę do domu i tutaj zostaną moje dzieci same, czy ja po prostu doczekam tej abolicji. I tak naprawdę my działaliśmy tak, powiedzmy, w ukryciu, bo spotykaliśmy się w Fundacji Frog. Te nasze spotkania nigdy oni byli tak po takie jak w czasie Solidarności, powiedzmy, że wszystko było tajne, tylko już wtedy, jak było wszystko przygotowane, my normalnie wyszliśmy przed Sejm i w momencie, kiedy my wyszliśmy przed Sejm, musieliśmy zgłosić to w akcji do Straży Miejskiej, do policji i nam było wszystko jedno. Policja była wokół nas, ale oni tak naprawdę nie wiedzieli, czy my jesteśmy legalni, czy nielegalni. Dlatego ta odwaga, ten po prostu, nie wiem jak określić, dodawało nam siły i ta pewność w to, że prezydent Bronisław Komorowski jest na tyle po prostu dobrym człowiekiem, że on rozumie każdy problem i zrozumiał nasz problem nielegalnych migrantów i potrafili nam pomóc wszystkie. Oczywiście, że bardzo było za, bardzo było przeciw, ale po prostu tych, których byli za, było więcej. Dlatego było nasze zwycięstwo.
Thank you, Lesia. Are there any other questions? So probably I will just have a last one, please. It's probably more to Lilana. You mentioned that, as far as I remember, 21 out of 27 EU countries had some regularization measures. Could you please describe the rest of the countries? Meaning, what, if you have information, what were the major concerns apart from this amnesty tourism or the threat that there will be more newcomers without regular status? Are there any arguments on the other side which were raised in this debate? Thank you.
I don't actually have the information of which those countries are, but I can send you the study that I took that from. But it certainly hasn't collated it in terms of arguments against, because even the countries that have these regularization programs normally say the same arguments against as well. A lot of the mechanisms that are in place in member states are very quiet, they're very discretionary. Officially, as Sebastian was presenting, countries like Germany that officially are very strongly against any amnesty, of course not. They have these as well. They do actually carry out these programs, so it's not necessarily that you can see from who hasn't and who has. It's probably the countries that are newer EU member states that have lesser migration, and so a newer issue for them, rather than it being that they have different ideas about the benefits or potential negative impacts of regularization. I mean, the arguments are the same that we hear for any kind of progressive and rights-based approach to migration, that more migrants will come. This is the classic, that it somehow legitimizes irregular migration. I mean, these are the same things that are obviously political concerns for governments as well, without getting into a discussion on all the politics about borders and nation states. But I mean, those would be the main things. But it seems that, as all the speakers have highlighted, the reality is much stronger than that. So.
Thank you very much. So that will be it for the first panel. We are a little bit behind the schedule, so let's say that we will start, I hope that 20 minutes will be enough for the break, so we will start at 11:35. And in the second panel, which will be in Czech, again, translation will be for our guests, so for those who don't speak Czech. And it will, during the second panel, we will discuss the potentials and the problems of regularization in the Czech Republic. Thank you.
So we followed it very closely as
jako iniciativa roku, iniciativa roku, mali iniciativu školské peníze, peníze za samozřejmě intervenci abolici, jako tak naprawdę w Polsce właśnie nikto nie znaczy do regularizacji, jak rozsypywanie migrantów. Przyjęła inicjatywa, że po 2 rokach.
So they didn't actually know whose initiative was implemented, but they found out the United States Federation 2 years after the last one.
Yeah.
Jo, já jsem si říkala, že ho někde mám.
Strašně laskavá, jsem si říkala. No, tak to je super. Děkuji.
Ahoj, ahoj. Ježiš. No, my jsme... Jo, protože takže myslím, že to jedna z tlumočení by mohla ale asi aby měl nějaký break, tak jestli můžu třeba jako vědět nebo tak ale tak se s ní domluv, jo? Zkus se s ní domluvit, protože Lesie, myslím si, že Marek říkal, ale ještě se jí můžu zeptat. Jo, tak ona jako obecně jako ráda, nebo ráda. Říká, že v toho má trošku dost, těch osobních, že jo, nějakých příběhů a tak, ale že prostě, no.
Jo, super. Teď to vypínám právě.
No, krásný. Já jsem právě jako nemohla odejít, abych se vás zeptala, tak super, děkuji. No.
Ta slečna se ptá, jestli by šla nějak stáhnout klimatizaci.
Nešla. Nejde vůbec. Jako nefunguje, jo? Prostě puštěný topení na nějaké zatopení, nemá se to topí, takže jsem se až to nejde vypnout.